of property right was not reasonable and therefore was not privileged at all. Public necessity, the privilege to reasonably invade property rights in the face of an emergency, an absolute privilege if the emergency threatens the general public. Private necessity, a privilege to reasonably invade property rights in the face of an emergency. A limited privilege, the person availing himself of the privilege must pay for whatever damages are caused. So long as the invasion of property rights is reasonable, however, that person is not a trespasser. Now we have one affirmative defense that applies to all the intentional torts. It's very simple. It's an affirmative defense called consent. Consent means willingness. If I am willing for it to happen, then it isn't a tort when it happens. Willingness is a complete defense to all the intentional torts. It's called consent. But I want to give you one little warning about consent. If you induce my consent by deceiving me, by defrauding me, by telling me a lie about the nature of the thing to which I'm consenting, then my consent doesn't count. And you don't have a privilege to do what you do. Suppose, for example, that you tell me you're a police officer chasing a dangerous criminal and you must have my car immediately, so I turn my car over to you and you drive it away. Turns out you're not a police officer. You weren't chasing a dangerous criminal. You just wanted to go for a joyride. So I sue you for trespass to chattel, maybe for conversion. And you say that I consented to your act. Have you got a defense? The chances are you haven't, because you induced my consent by defrauding me, by lying to me about the nature of the thing I was consenting to. And for that reason, my consent is of no effect. Some of the writers say my consent is vitiated, which simply means undone. Okay, we've talked about the intentional torts. We've talked about affirmative defenses to the intentional torts. It's time we talked about negligence. Now, remember what our method was when we were discussing intent? We began by examining the concept of intent as a basis of liability, and then we looked at some intentional torts. That's going to be the same approach that we use in our discussion of negligence. First, we're going to discuss what negligence is as a basis of liability, and then we're going to look at some torts that involve negligence as a basis of liability. So let's start with the concept of negligence itself. And as always, we start with a definition. Negligence is usually defined as a breach of the duty of reasonable care. A breach of the duty of reasonable care. And I want to give you a warning here. You'll probably learn various shortcuts as you study torts, and one of the things you may try to do is reduce every definition down to a word or two, and that's probably a good idea when you study. But be very careful. Don't say negligence is a breach of duty, because negligence isn't just a breach of any old duty. Negligence is a breach very specifically of the duty of reasonable care. And you'll keep yourself out of trouble if you remember that. The duty of reasonable care. So, the first important issue that you'll probably have to confront when you're dealing with negligence as a basis of liability is whether the defendant owed the plaintiff a duty of reasonable care. Because one thing that separates lawyers from lay people is this. Lawyers realize that not everyone owes everyone else a duty of reasonable care. As a matter of fact, courts have said repeatedly that when they use the word duty, they're frequently just using a shorthand expression for a conclusion that they reach based on public policy considerations about whether a certain kind of defendant should be liable to a certain kind of plaintiff for a certain kind of injury that happened in a certain kind of way. And when courts decide whether a defendant owed a plaintiff a duty of reasonable care, they consider an entire battery of factors, a whole variety of factors. In fact, if you tried to make a list of the factors that courts have considered in deciding whether a duty of reasonable care was owed, you'd probably be making a pretty long list. But there are certain factors that are considered more often than all the others, and those are the ones that we have to look at. And probably the most important of all is foreseeability of the risk. Because whenever courts talk about whether a defendant owed a plaintiff a duty of reasonable care, they talk about whether the risk that led to the harm was a foreseeable one. In this connection, foreseeable means something that the ordinary person or reasonable person would have anticipated, something the ordinary person or the reasonable person would have recognized to be a serious possibility. The foreseeability of the risk. You may have read a case, for example, in which an English court decided that it wasn't foreseeable that pipes would freeze because as long as anybody could remember, it never got cold enough in that town to freeze pipes that were buried the way these particular pipes were. And the court found that that risk wasn't foreseeable, and therefore the defendant who had owned or maintained or installed the pipes didn't owe a duty of reasonable care to protect the plaintiff against the possibility of freezing. Well, you can certainly see the merit in that argument, but I'm sure you can see the flaw in that argument also. It's a little bit like saying, it is not foreseeable that I'm going to die because, after all, as long as anyone can remember, I never did die before. So be real careful about making the kind of argument that says something is not foreseeable because it never happened before, although that certainly is something worth talking about. In addition to the foreseeability of the risk, another factor that the courts frequently talk about is the foreseeability of the plaintiff. It isn't enough that it was foreseeable that somebody would be in danger. It must also have been foreseeable that someone in the plaintiff's position would be in danger. And that's what that famous Palsgraf case was about. If you haven't read the Palsgraf case yet, I have no doubt that you're going to be reading it before your torts course is over, because that case is discussed as part of almost every torts course in the United States. What happened in that case is that Mrs. Palsgraf was standing on a railroad platform, the Long Island Railroad in New York, waiting for a train to come. And she was standing under a scale which had been hung for the purpose of weighing cargo that was going to be shipped on the train. A train came in and it wasn't the train she wanted, so she continued to wait. And the train began to pull out of the station. As the train was pulling out of the station, a stranger, call him the unknown passenger, UP, because we never did find out what his name is. The unknown passenger, Mr. UP, came running to catch the train. He had a package under his arm. The package was wrapped maybe in brown paper, maybe in newspaper. There's some disagreement. But in any event, it was wrapped as an ordinary package. And he was running to catch the train, and the train was already leaving the station, and a conductor came out on the back platform and reached out and grabbed UP by the wrist and said, "I'll help you aboard the train," and gave him a yank to jerk him aboard the train. And when he did that, the package dropped out from under UP's arm, and it fell to the tracks. It happened to contain explosives, and when it hit the tracks, it exploded, and the scale under which Ms. Palsgraf was standing fell and struck her on the head, injuring her. And she sued the railroad. And she said that the railroad should not have pulled UP aboard the train the way it did. Of course, a railroad acts through its employees, so when the conductor pulled him aboard the train, it was the railroad that was pulling him aboard the train. She said the railroad should not have pulled him aboard the train. And the question that arose was whether, when the railroad pulled UP aboard the train, it owed Ms. Palsgraf a duty to do so in a proper manner, in a reasonable manner. And after a series of appeals, the case came before New York's Court of Appeals, which is the highest court in the state of New York. And Judge Cardozo, Benjamin Cardozo, wrote the opinion that has become famous. He said that when the railroad yanked UP aboard the train, there were many risks that were foreseeable. Oh, we can see a few of them ourselves. It was possible that UP's shoulder would be dislocated. It was possible that he'd be knocked down onto the tracks and injure himself in the fall, or that he'd be struck by a train, or that his package would drop and he would lose a valuable thing. But, Judge Cardozo said, there was nothing about the package that would have led the ordinary person to expect or anticipate, or that magic